Good afternoon, everyone in the room. I think we're going to get started. And good afternoon or good morning to those participating by webinar. Appreciate everyone joining. We have a real interesting topic today. I'm George Constantine. I'm chair of the Nonprofit Organizations Practice Group here at Venable. And we have these events on a monthly basis on different topics that are of interest to the nonprofit community. And today should be a good one. We're talking about internal investigations at nonprofit organizations. Not something anyone wants to have to deal with, but it's a pretty regular occurrence in our world. And when you do it, you want to make sure you're doing it right. And we've got some great folks on the panel here who have some good experience working on these sorts of things. I'm going to introduce each of them and then turn it over to Eric to get things started. If you have any questions here, please understand there's a microphone that we want you to talk into so the people who are participating by webinar can hear you as well. So I'll start first with Jesse. Jesse Rabin, to my immediate left here, has been practicing law for more than 25 years. Presently, he's general counsel of the Trust Companies. He previously served as general counsel to the Common App nonprofit organization. If you have kids who've been college age, you know what that's all about. And then prior to that, spent a number of years, almost 18 years, working in-house at the American Psychological Association. So tremendous amount of background, particularly from the in-house perspective. We're really happy to have you here, Jesse, and thanks for joining us. And in the middle here, and to Jesse's left, is Eric Berman. He's a partner in the DC office. He is been a colleague of mine for a number of years. He works on a number of litigation and investigation matters with a lot of nonprofit organizations, and he's been part of a team that have been involved in certain investigations that we've done over the years. He also works with clients facing state AG actions and Federal Trade Commission enforcement actions as well. And finally, to my far left is Doreen Martin. Doreen's a partner out of the New York office of Venable and has a leader in the investigations practice, works on litigation matters and employment defense matters for a number of our clients, and has been involved with a number of our investigation matters for some of our nonprofits as well. With that, I think I will turn it over to Eric to get things going.
Sure. Thank you, George. Hi, everybody. Nice to see you. It's nice to see you in person. I think it's been about 3 years or so since I've done one of these in person, and we have a great turnout here. Welcome to those of you on the Zoom. At the risk of repeating some of what George said, I do want to give a special thanks to our friend Jesse. It's great to do these things with friends, and some of you may know Jesse. He's long been a leader in the nonprofit community. He's a leader with ACC, the Association of Corporate Counsel. He's a friend of the firm. And I think that, especially for a topic like the one that we're doing today, you could really give a useful and unique perspective on what it's like for an organization to experience an internal investigation from the inside. So thank you for being here, my friend. We do have slides that will guide our presentation, as is usual, but that's not quite our style. We don't want to talk at you for an hour. We don't intend to. If you have questions, please ask, or at least if you're in the room, we have microphones around the table, and Christine can help facilitate that if you want to jump in with any questions. And we'll likely just bounce concepts off each other and make this more of a dialogue than a speech. As George mentioned, today we will be talking about how to navigate an internal investigation at your nonprofit. George said it was interesting. I was about to sort of make a joke that it's not quite as fun and sexy as some of the other topics that we often present to this audience. Protecting your IP or new and different ways to fundraise, but it really is important. If there is an allegation of misbehavior or an allegation of illegality at your organization, as long as that is ongoing, it could have really harmful effects for your organization. It can hurt staff morale. It could violate your mission. In extreme circumstances, it could threaten your exempt status. If it's publicized by, say, a whistleblower, it could be a PR nightmare for your organization. So, as George said, you definitely want to do it right. You want to stop the underlying behavior. You want to gather the relevant facts, and you want to take appropriate action. Naturally, the clicker doesn't work quite on time. So Before we get to the sort of nuts and bolts of how to conduct an internal investigation, before we get there, presumably your organization will have laid the groundwork to do this effectively by implementing written standards of conduct and policies and procedures. You know, I sort of, my imperfect analogy is, you know, you can conduct an internal investigation without these things. To me, it's like building an IKEA piece of furniture without the instruction manual. I wouldn't advise it, even if it's technically possible. You want to have clear written policies that outline compliance expectations. It's not a legal requirement, of course, but many organizations have a code of ethics applicable to all employees, volunteers, board members. I might throw consultants in there, something that articulates your organization's core beliefs, and you know, not something that is just sort of aspirational and it looks good on your website either. It's something that has teeth, is understandable, and a violation of which is enforceable. You want your organization's policies to cover, you know, certainly the things that are identified in a 990, right? Conflicts of interest policy, whistleblower policies, document retention, gift policies. You know, if you're in Georgia's world, if you're a C6, an antitrust policy. But I think we have some more here. I think the key is what we have at the bottom here. You know, you want these to be sort of standardized, user-friendly, easy to read, accessible to people. It's a due process issue, right? If you want people in your organization to be on notice of the compliance expectations that they will be measured by. And at the very bottom, define key terms. You know, I've litigated some of these issues. So I sort of, you know, imagine the worst case scenario and work my way backwards. If you don't define key terms, if your policies and your code of ethics are written with some ambiguity, if they are vague, that will make it more difficult to defend your determination that there's been a violation, and it will make it more difficult to defend the merits of your investigation if it's challenged.
And I'll just jump in that I don't know how many people can remember their first day at their current position, but you're inundated with HR, then you're going to finance, then you're going to get your payroll stuff, then somebody might take you to lunch, then you're meeting everybody, and the big employee handbook that they give you just kind of ends up sitting on your desk. Maybe you sign, yep, I acknowledge that I got it and I read it and understood it, which 98% of the people do not. I would encourage your HR department to go back in about 3 weeks and have one-on-ones with all the new hires and sit down and go over some of the key elements again, and obviously give them notice and say, you know, just review it and let me know if you have any questions. This way, that element of due diligence has been done and it's incorporated, and people understand that they have another bite at the apple, and that it's not just a 3-ring binder sitting up on their shelf.
And yearly trainings are also very helpful when you're doing any type of employee training. You should throw in your policies and go over them and make sure that people really do understand. Because when we conduct investigations and we ask about the policies, so many people said, I've never seen that policy. I didn't even know it was a policy.
Yeah.
So it's important to do these trainings.
Since we're all chiming in, I'll add one too. There's with a lot of you in the nonprofit community, the code of conduct, the code of ethics could mean different things. It could be a code of conduct for the board members, could be a code of conduct or code of ethics for your members of your membership organization, or it could be applicable to staff. It's really important. We've talked about this internally in working on those policies to make sure there's consistency. We talk about cross references, particularly with regards to the employee handbook, that the provision on ethical behavior or avoiding conflicts of interest within your employee manual should sync with those other policies to the extent that they would apply as well. And make sure that you don't have a situation where an employee who may have been engaged in some wrongdoing would have some possible out because they're being sort of looked at under the wrong policy.
Absolutely. I'm sorry, I have to look up here to see if our, there we go. All right. So what are the standards of proof that the law requires? So the standards governing civil and litigation, civil and criminal litigation, at least in U.S. courts, are different than the standards that would govern what constitutes a defensible internal investigation, right? So, if you're in litigation and it's criminal, allegations have to be proven beyond a reasonable doubt. That's the highest standard of proof that we have under our system. Most civil litigation is governed where the allegations have to be proven by a preponderance of the evidence, basically a 51% standard, but the evidence for the claim has to be more probably true than not. There is a limited universe of civil cases that are governed by more of an intermediate standard, sort of lower than the reasonable doubt criminal standard, higher than preponderance of the evidence. As the slide notes, this can be the standard in cases involving fraud or where the plaintiff seeks equitable relief. It is also reserved for a sort of a narrow universe of civil cases where there is some sort of liberty interest at stake, deportation, for example, or committing someone for mental illness, or where there's a presumption of legality relevant for this audience, like if there's a case involving a breach of fiduciary duty. Standards involving an internal investigation are different. You want to conduct the investigation in good faith. You want to follow where the evidence leads you without a preordained conclusion. And you want to provide due process. You want to give the target or the accused notice of the allegations, an opportunity to be heard. And I think importantly, that last bullet, your conclusion, your determination doesn't have to be right, just has to be reasonable. So what does that mean? It means that if your decision is challenged in a lawsuit by the target against whom you took disciplinary action, the court is not going to substitute its own judgment for the judgment of your board or your management, whoever made the determination. As long as there is a reasonable basis for your decision, it is supported by facts. We'll talk about putting things in writing, creating a record. As long as your determination is supported by the record, a court must defer to what your organization decides, even if different conclusions could have been reached under the same facts. Tie still goes to the organization who conducted the internal investigation.
Question?
Sure.
Thank you. How's that? Oh, it's loud.
Yeah, good.
Quick question on at least like kicking off the process. What does the law say about like the time frame in notifying the employee that like an investigation's underway? Because sometimes I think clients they're hesitant because if you give it up right in the beginning, they're afraid that maybe some of the information that might help their case later on could be destroyed. And obviously there's like legal holds you can put on emails and things like that. But what does the law say in terms of like timing and when you have to notify the employee before you kind of get things underway and start interviews and start the process? I was just wondering that.
I think as long as you're doing a prompt and thorough investigation, right? You have to understand the facts first before you can start notifying the accused of or the employee of what's going on. So as long as you're prompt and the time is reasonable, that should be sufficient under the law.
I mean, I would add to that. There's many reasons why you want to act fairly swiftly while providing due process, right? A notice and an opportunity to be heard to the accused. And you may have experienced this on the inside. As the misbehavior is going on, your staff is going to be distracted. They might be unhappy. They might quit. And so there's no legal definition for what constitutes promptness. It's sort of like the definition of obscenity. You know it when you see it. It's based on the facts. And I'm glad that you raised the litigation hold, and we'll talk about that later because that is a protection against somebody catching wind that they're under investigation and just deleting their inbox or, their PSD files.
Your organization's policy might have a specific time frame, though, that you would have to adhere to. Sometimes there's an investigation protocol that's followed by an organization, and it has to be within X amount of days. And that's something that if it's in your policy, then you should follow it. There's usually some discretionary language in there where you can get a little more time, but you should, if your policy has a specific time frame, then you should definitely adhere to that.
Also, in every organization, it's just, I don't mean to be trite here, but you have to kind of go back to 6th grade, and my daughter's in 6th grade right now, so I know of what I speak. The moment you start the investigation and you say to somebody, but don't tell anybody, you have to think that somebody's going to come out and then, hey, this investigation is happening. So it's better to act quicker, start to notify the people. You get the legal holds in place. You're telling people not to destroy things, not to delete things. And so then there's bigger repercussions if they actually do.
And I'm sorry, is there a follow-up or?
Thank you.
Thank you, sir. Accepted around here. And actually, I love that question because it segues. I mean, that's essentially what the next slide is. So we can, we may not have to spend much time on it, but yes, when do you need to investigate? There's actually some language in the EEOC's manual which says that if you're the employer and you have your adequate policies and procedures in place, all the stuff that we talked about a few minutes ago, but then you fail to act on them by conducting a reasonable investigation, then you haven't done your job, right? So knowing is not enough. You have to act. You need to investigate when any information regarding wrongdoing comes to light from any source, right? Some organizations have a tip line or a hotline. There's more formal complaint procedures. We've talked a little bit about water cooler. I don't know if organizations have water coolers anymore, but the equivalent of water cooler gossip. And is that enough to put you on notice? And the answer is yes. I mean, if you don't have to have direct, physical, actual notice of wrongdoing, you can be placed on constructive notice that you hear enough smoke, and now you have to go investigate whether there's a fire.
And when you're in-house and somebody comes into your office and says, hey, can I talk to you? The message to them is, okay, whatever you're about to say, I may not be able to hold in complete confidence, because if you tell me something, I may have to bring it forward. And that can be concerning for somebody. They may think that their name is going to get out there. You can protect somebody's name to a certain extent, but at some point their name may have to come forward. But I'm sure everybody has also heard the story from the employee. Well, that person is untouchable, or management's not going to take it seriously anyway. So what is it? Why should I even bring it forward? The moment you hear that, then you need to call your management team together and say, what kind of culture have we created that doesn't allow people to come forward and have an honest conversation about some of the things that have gone on? And Eric mentioned, you can do these 800 hotlines. We used it. We never got a call. We actually built our own internal email that was an anonymous system, and we get one or two occasionally, but it never really rose to anything. But then you can go into the COO's office, you can go into the general counsel's office, or you can go to HR, though a lot of people look at HR as an enemy in some way. But you have to provide a lot of different avenues for your staff to come forward to talk about things.
Clients will often ask, do we really need to investigate this? And the answer is, if it will pose a risk to your organization in any legal way or reputationally, then the answer is yes, you should investigate. Now, the scope it could vary depending on the severity of the allegations, but investigation should be done if there's any legal or reputational risk at stake.
And so then, once you've determined whether to investigate, then the question is, who should investigate? Doreen should, at her standard hourly rate, with retainer.
Thank you.
The honest answer is, any number of people can investigate. The investigator should be independent, objective, credible. There are any number of situations where, frankly, I think it's perfectly fine for, if your organization has an in-house lawyer, the in-house lawyer can conduct an investigation. Even if there's no in-house legal function, but there's something like a chief compliance officer, that is a possibility. Obviously, that is more cost-effective for the organization, and depending on the nature of the allegations, that could be, more than appropriate. Bear in mind that there always exists this risk that company management, effectively tasked with investigating itself, might not be viewed as sufficiently objective, sufficiently independent, and that really becomes an issue if, for example, you're in a situation where you might want to or have to share the results of the investigation with a government regulator that's conducting a concurrent investigation, or if you have to defend your determination in court. Those are typically situations where you would think about bringing in outside counsel to conduct the investigation. And I'll say something against our self-interest, because we love developing long-term relationships with our clients, nonprofit and for-profit. Frankly, sometimes being the organization's regular, long-time outside counsel, where we sort of know where all the skeletons are hidden and we know the business very well, we might not be viewed as sufficiently independent. Sometimes you bring in a different law firm as sort of your investigation hired gun. That happens with some regularity. Sometimes you get separate counsel for individuals, but at all times you want to keep objectivity and independence in mind, and you want to be sensitive to potential conflicts of interest. You don't want senior management, particularly those who could be involved in the allegations, who could be the subject of the allegations, to place their thumb on the scale, to have any undue influence over what's going on. You're going to want to wall them off. So those are my thoughts on.
And this could probably be said with each of the points that you're making, but obviously a good whistleblower or other type of policy that would be in place would make clear that the different avenues as to who investigates depends largely on those issues like conflicts of interest or whether a particular person up the chain may be implicated.
That's absolutely right.
So now you get to the investigation. You've considered who's going to investigate, and now you have your investigator in place, and you have to now plan for your investigation. The first thing you should do when planning is to create an investigation plan, right? The investigation plan is going to be your roadmap, and it's going to help keep you organized. And as you go through the investigation, it could take several months. You want to refer back to your initial investigation plan, and you may have to tweak it along the way as you go and update it. But it is your roadmap, and it is something that you should turn to frequently during your investigation. So what goes into that roadmap? The first thing that should be in the roadmap is your scope, the scope of the investigation. And you should really seriously think about the scope, because establishing that parameter is very important at the outset of the investigation. If you define it too narrowly, you might miss something. If you define it too broadly, it might seem like you're going on a fishing expedition. So you really do want to think about your scope. And I like to be very specific. I like to put it in question form, right? If X did X violate Y policy when he or she did whatever, right? That's your scope. That's your question. So while you're investigating, your goal is to answer that question. The next thing you want to do is identify the key players in management involved, right? Who are the stakeholders? Who are the main people involved in this investigation? You also want to, and this is a very important step, figure out where's the evidence? Where are the documents? Where are the emails? Where are the text messages? Where do I find all this information that I'm going to want to gather and review before I do any witness interviews? In order to do that, you're probably going to have to meet with your IT, someone in the IT department, to help you figure out where everything is located. You're going to want to talk to supervisors and managers. You really want to brainstorm here and think, where am I going to find the evidence that I need to establish whether or not there's been a violation of law or a violation of policy. The next thing that you want to do is look at your policies. We've been talking a lot about the policies already, but they are really key because they help you figure out what elements do I need to establish in the course of the investigation. And I like to just copy and paste the relevant policy sections and put them right into the investigation plan. So I know exactly what I'm looking to prove when I'm conducting the investigation. The next thing that you want to do is create a witness list, right? That's different from your key player stakeholder list. This is, who do you think you're going to interview? Who is going to lead you to the facts that you need to come to a conclusion and a determination? So when you're doing the witness list, Eric and I were talking a little bit about this before this meeting. We said, well, we always interview the complainant first, right? It's very typical to interview the complainant first. And then you want to interview some of the witnesses that you think are going to have the credible information or have any type of relevant information to establish the facts. And you really do want to leave, in most cases, the accused or the wrongdoer to last, right? So you really do want to think about your sequence. You don't want to just go at it and just start interviewing people when they're available. You want to go in an order that's thought out before you begin the investigation. And so I like to include that order, the sequence, in the investigation plan. The next thing you want to do is consider your logistics. Make sure you have a place that's quiet and confidential, where other witnesses who might be walking by are not going to be able to see who you're interviewing. You want to maintain confidentiality as much as possible. So you really do want to maintain that confidentiality and make sure that the room that you're in is in a place where people aren't going to frequently walking by. You also want to time these interviews with witnesses so there's not too much disruption to their workday, right? These investigations oftentimes become big disruptions to the organization. And as the investigator, you want to try to do as much as you can to minimize that disruption. And the last thing you do in the investigation plan is look at the personnel files of the people you are going to be talking to. You get a lot of information from those personnel files. Are they on performance plans? Is there any previous history of making complaints? And so these little things that you can glean from these files are very helpful in coming up with your overall plan.
And just one thing that I would add before we go on to the next slide, and it's the bullet about identifying the existence and location of evidence documents. Every 6 months, you can update what a document is. I feel like I'm still sending litigation holds to clients that crib the federal civil rule 34 definition of a document. The technology moves a lot more quickly than lawyers do. We have clients who use Slack and Jabber and Skype, and not only is the technology changing, but I think the level of informality about how people communicate on some of these new technologies. That might be where you find the real, the real nitty gritty, because people think, oh, well, I can just delete this. So working with IT is key.
And it also helps, obviously depending on the size of the investigation, to have like your guys' view on this too, a point person that is delivering the documents, let's say to Doreen, saying, okay, here's all the documents, but keeping a list. So everybody understands what the company is given to counsel or whoever's running the investigation to review, And so you're not going back and wondering if somebody did this or looked at that. And then to Eric's, one of his first points, it starts to allow you to build this history of what's going on in the investigation. So you're always on top of it, because once 3 months goes by or a day, you're not going to remember what you gave, what you looked at. So it's best to have your records as good as possible.
You have a question?
Point about different communications tools. I'm not even sure exactly how to formulate this question, so bear with me. There are tools that are, sanctioned by an organization or approved for use, and then there are tools that are not, and then there are some that may not have any particular classification. In your experience, how have you handled that for internal investigation purposes? I'm not talking about litigation, just talking about internal investigation, because there can be a conflict with like the employee privacy policy, for example.
I think I understand the question, and I think it's an excellent one. I typically, and I will certainly defer to Doreen on this as well. I cast as wide a net as is reasonably possible. My standard is, does the company have actual or constructive possession, custody, or control over the documents? And so if it is someone, texting on their phone, this isn't, Venable issued, but it's someone texting about a work-related issue, even on a personal device. To me, that's collectible. It's a document that falls under the scope of the investigation. I think you sometimes see this with, social media. Is it a personal social media account? That obviously moots some of the privacy issues that you're raising. But if it's a social media account that's personal in nature but references the organization, I think it's fair game. And I kind of go back to something Doreen said 10 minutes ago. If it's anything that potentially exposes your organization to liability or disrepute, then you as the organization should care about it and try to collect it.
We often work with vendors too, who collect all the evidence, the emails and the texts, whatever platform is being used in the organization. And we run very targeted search terms, right? So we're not reading every email for specific custodians, right? We are targeting key search words that we think will, based on some few emails that we review, will say, okay, we know that this is what, when the meeting took place that we're investigating, or a certain buzzword that's been used over and over in emails, and that's how we target it. And so we're not, reading all of the personal emails that come along with an organization's use of their devices to communicate, but it's very targeted. And so privacy is somewhat maintained.
And in the unfortunate event that you end up in litigation over the results of your investigation, there's protective orders. There's in-camera review by the judge. There's, the ability to redact PII, and opposing counsel, is not going to put up a fuss about that. At least they shouldn't. Maybe you have that fight, but that's another protection.
And being clear in your policies also about if you're using your personal device to send text messages, during phone calls, people are back channeling, and the message to all staff is if it's work related, it's discoverable. And we had to take somebody's phone away, and they had a conniption because all of their family photos, there was nothing bad on it, but all of their family photos, everything personal was on this little device. And to take it away for a couple of days to say, we need to take a look at something, that sends such a chilling effect that I think if it's ingrained in your policy and people understand it, they're less likely to be so flippant on text and Telegram and WhatsApp and whatever else is out there.
That really is going back to 6th grade. We have to take your phone away.
Yeah, exactly. Yes, Eric.
Yeah.
So you've done your investigation plan, and at the same time, you should be drafting a litigation hold, right? You want to draft litigation holds when you can reasonably anticipate litigation. And so what are the triggers of reasonably anticipate litigation? That would be if your organization received a subpoena, if you received a demand letter, or a complaint. If you have any doubts about whether to send a litigation hold, you should err on the side of sending it. It's always better to have preserved the documents and make sure that there's no spoliation issues down the road than not send the litigation hold because you're not sure if you really need to do it. You should always send the litigation hold to the IT director, right? Because they're the ones who will stop the automatic deletion processes that your organization has, and they can really control. So even if it doesn't go out to all specific individuals, it should at the very least go to the IT director because they can freeze everything. They can make sure that everything's preserved and not going to be deleted. At this time, you're also, if you're issuing a litigation hold, you should probably also consider whether or not you needed to notify your insurance carrier, because in certain situations, the carrier does need to be put on notice. So this is at the same, this is when you should be also notifying the carrier. So here is just a list of the information that would need to be preserved when a litigation hold goes out. The next thing that you should be doing is stopping the underlying conduct. If there's any type of continuing behavior, you need to make sure that you have some interim measures put in place. You do want to be careful of the interim measure that's put in place because you don't want it to be perceived as retaliation. And you really should consult with legal counsel, your inside counsel, when you're deciding to put someone either on suspension or you're going to reassign the person or change in shifts or job descriptions. That's something you do want to consult with inside counsel on. Okay, so now to me, this is the fun part, preparing for the witness interviews, right? This is where you really start to build your witness outlines, right? What are you asking these witnesses? And you really, again, going back to the policy, you want to make sure you know what the elements are. You want to know the documents, all the documents that you've preserved, that you've collected. You need to review those documents. You want to know those documents inside and out. You want to create a chronology of the documents so that you can easily, while you're talking to witnesses, you can easily go through it and know when in date order what's occurring. And that's how you really are testing credibility too. If you have the dates because you have all of the emails, you can test the credibility of your witnesses as you're going through the events with them, right? You're trying to extract the information from them, and the more prepared you are, the easier it is to do that, and it's easier to challenge witnesses. It could be that their recollection is just not good at that time. They can't recall certain facts. If you know the facts, you can refresh their recollection and say, well, could it be, if they're deciding between dates, I can't remember if it was this date or this date. I'm like, well, if I show you this email that you wrote, would this refresh your recollection as to that it actually occurred in November? And that's very helpful. But if you don't have the knowledge of those documents, it makes it a lot more difficult to do that during the interviews. The other thing that you want to do is, again, use that personnel file to help you ask them questions about, or develop the questions asking about their past performance, whether or not they've ever been put on PIPs, whether or not they've had similar allegations raised against them, whether or not they've raised these types of allegations before. All that's very important and should be built into your witness interview outlines. Okay. So now you get to your interview and you've prepped, you know the documents and you have your outline, you know the elements that you need to establish. And how do you conduct these interviews, right? We went through this about the logistics. You want to make sure you're in a private place. You want to explain right away to the witness who you are. If they don't already know you, you want to explain to them who you are. If it's an attorney conducting the investigation, you want to make sure you're giving an upjohn warning. And in the upjohn warning, you want to explain to them that the attorney, the investigator, represents the organization. They do not represent the individual employee. Normally, when you say that, they're going to say, well, do I need my own attorney? And your advice is, I can't give you any advice about whether or not you need an attorney. And sometimes decisions are made by the organization to provide certain witnesses with attorneys ahead of time. So they might come in with an attorney, and organizations might be willing to pay for that attorney. Other times, witnesses want an attorney, and you can allow them to have an attorney, but you just make very clear that the organization is not going to pay for that attorney. So, Jesse, do you have experience with that in the employees asking for attorneys?
We had, so at one of my former jobs, we had almost a 10-month investigation. It was torture, and that the organization was involved in the enhanced interrogation program under the Bush administration. We did have a lot of employees and board members who were wrapped up in it, and board members came forward and asked for attorneys. And in that instance, we provided them and paid for those. There are instances where, like Doreen was saying, that you're not going to pay, but there is that moment when you're interviewing the person that, as Doreen said, they may ask for an attorney because that's what they've seen on TV. They're nervous. And I would say that probably the most well-prepped person is going to be somebody who actually sat on a jury and realizes how boring trials really are, as opposed to the TV stuff. But that's what's in the person's mind, that somebody's going to be like in their face, well, where were you on the night of this or that? But it's just this, I've watched, people with all of their expertise ask questions, and then slowly you suddenly see the drain starting to swirl as the person has got caught up in their own answers. But yeah, you'll see, hopefully you don't have to go through these, but there is that one moment of hesitation when they do ask, that they're trying to figure out, because they're also thinking, if I do ask for an attorney, does that mean I'm guilty of something? Which obviously it doesn't. So.
The other thing you want to tell them right up front is that you can't guarantee confidentiality, right? You can do your best to do the investigation in a discreet and confidential manner, but you can't guarantee confidentiality. People need to know, people do find out, but you can just assure them that you are going to keep it as confidential as to the greatest extent possible. You also, before the interview begins, wants to tell them that there's a non-retaliation. Most organizations are required to have a non-retaliation policy, and you just want to make sure that they know that just because you're being spoken to, you may not be a subject or a target in the investigation. You might just be a witness. You're not going to be, if you do feel retaliated because of your participation in this investigation, you should immediately notify someone and just explain that to them. It's also helpful for witnesses to know that they're just witnesses, right? If they're not the subject or the target, just say, we're talking to you today because we think you may have relevant information. That right away, you can see they feel much more at ease. They know they're not being accused of something. They didn't do something wrong. You're just talking to them because you think they might have some facts. So it's very important to put the witness at ease when you start the investigation. When you're doing the interview, it's important to let the witness talk, right? You want to explain some questions to them, ask some questions, but ask very open-ended questions. Let the witness talk, let the witness tell their story, what they have, what the information they have. And then you can drill down asking your specific questions, but always leave the beginning part of the investigation, the interview open so that they can really tell their story. And you get a lot of information when you do that. And then you can go back to your outline and drill down on the specific elements that you really do need to establish. Again, getting the who, the when, the where, the what, asking in all of these witness interviews, are there any other witnesses that you think I should talk to? Are there any other documents that you think I should see? These are really important questions to ask in any interview.
And I would add also, that once more than likely, let's say you're investigating a sexual harassment issue. You can guarantee that some of the people that you're bringing in know or have heard about the behavior. And so once they relax, as Dorian said, you ask these open-ended questions, they feel more relaxed. They're suddenly going to start coming forward with, well, now that I'm here, can I just quickly tell you I experienced this or I experienced that? And more information comes out once they get comfortable.
So in the interview, you do, if you can, not everyone can do this, but you should try to have at least two people in the room. One person being the primary questioner and the other person being the note taker. It's sometimes very hard to do both, right? Because you're asking questions and you're like, wait, hold on a second, and then you have to take notes. It's a lot easier to maintain eye contact with your witness and develop a rapport going back and forth instead of constantly saying, hold on a second, I want to take good notes. So it's always important to have a note taker. It's certain organizations and certain policies will require that then the notes that are taken are reviewed by the witness and signed. It's not something we do as outside counsel typically, but I do know that HR and in-house counsel will do that. And Jesse, I know that we spoke about that earlier, and that's something that you've done before.
Yeah, it also gives them a chance to correct something or add something. And then with notes, I know I'm incredibly guilty of it. I hate having to turn around notes into some sort of credible document. But turning the notes around into a credible document in a very timely way is good, because you're taking notes as fast as you can. Your handwriting probably isn't so great, and you're going to go back in 3 days and go, what was that word again? Is that immediate, or was it this or that? Get it done in 24 hours if you can. Word now has a dictation function, so you can just read everything in and it'll just appear on the screen magically. I would at least recommend doing that if you're not going to actually transcribe it directly into typing it out.
Yeah, it's important to have a good record of the notes, because sometimes you go back months later and if you can't read your handwriting, then it's really not helpful. So getting a good memo, pretty contemporaneous with the interview, is definitely key. So the next thing we'll talk about is assessing credibility. This is probably one of the hardest things to do in an investigation, when, especially in harassment and discrimination cases where it's he said, or he said, she said types of allegations, and there isn't a lot of documentary evidence to back it up. You really do have to make your determination based on your credibility assessment. And so when you're conducting the interviews, it's important to keep these factors in mind. And then later, when you're doing your investigation report and you're doing your credibility assessment, you should go back to these. The first one is inherent plausibility, right? Do the allegations even make sense at all, right? Are they believable? Is there any credit to them? That's the first thing. The next is bias and motive. And this is where the personnel files sometimes come into play, because you can see if someone's been disciplined before or put on a PIP. You'll really try to understand what's the bias and motive here. What was is there any issue? Was the witness, is the witness impartial? Is there any reason that this witness is exaggerating or lying to the interviewer, lying about the allegations? Is there some type of grudge that's going on? Or sometimes there's underlying things that you really should be considering when considering the certain allegations. The next factor is demeanor. This one I don't particularly like to focus on as much. Witnesses are nervous a lot when they're talking to a lawyer, and they think that they're being accused of something or involved in some wrongdoing. And so you do want to pay attention to the witness's demeanor, but it's not something that you should make your determination on alone. I one time was doing an interview, and the witness was terribly nervous. I was sweating and wringing his hands, and it just, something wasn't right. I was like, wow, this person really is, has something that they're hiding. That was the first thing that I thought based on the demeanor. But I said, is everything okay? Are you all right? Do you need a break? And he said, my daughter went to the hospital this morning and I'm terribly worried about her. And I just like to step out to make a phone call to see if she's okay. And like that, you don't want to jump to conclusions. People have other things going on that could be causing them to react in a certain way. So I don't always focus on demeanor, although it's something to note. The next factor are prior incidents. Again, this comes from just talking to certain witnesses about whether or not has this person made complaints in the past? Are they a serial complainer? Has this person been accused multiple times before? So you want to consider that. The next two factors are probably the factors that I rely on the most in making my credibility assessments is the omissions and contradictions, right? Was the witness forthcoming with information? Was the witness, giving you all the details, or were they leaving things out and not until you approached them with it or confronted them with it, did they tell you the full story? So these are really important to look at omissions and contradictions when making assessments, because witnesses should come out with the information without you having to pull it out too much. And then corroboration. It's very important that you look at the evidence because that really will help you determine whether or not the witness is being credible, if there's evidence that corroborates what they're saying. And then finally, making a determination. So you have to take all of that information, your knowledge of the documents, the information you received from the witnesses, and collecting all of that information and decide, go back to your scope. Did X violate or X or Y policy when they did whatever they did? And you really need to consider all the factors in making a determination. And remember, when you're doing this, going back to Eric's point on one of the first slides, you don't have to be right. You just have to come to a reasonable conclusion. And then finally, it's making the recommendation. What's the corrective measure? Should a corrective measure be put in place? Or is there going to be some discipline? And I'd like to talk to Jesse, hear from Jesse about the actual implementation of the recommendations once they're in-house.
Yeah, and so, so from the outside counsel point of view, there's a joke that, client goes to jail and the attorneys go to dinner. And in some respect, so investigation comes to an end and outside counsel, they've got other clients and other matters to deal with. So you shake hands at the door and then you turn to your management team. It's like, okay, what are next steps? And, if you're not going to implement or take corrective action, then you're setting your organization up for more issues, not only morale from staff, but there could be legal issues, there could be problems with your 501c3 status. If you've notified your broker may call your insurance broker, your broker may call you and go, so what's the update, what's going on? And if you say, oh, I haven't done anything, well, then they're thinking to themselves, okay, you're going to take on a lot more risk, which is not where you want to be. But meeting with HR and in-house counsel, and it may be that you have to bring in your CEO to make some determinations, because it could be that some people are leaving, or you just need to tighten up some policies. And as Doreen alluded to in the beginning, trainings. What's lacking in your training? Like, what caused this? So really take a good look at your own selves, look at yourselves in the mirror and say, okay, how did we get here? Were there things that happened along the way that we could have stopped it? Did we not have a true open door policies that people could come forward with? Your outside counsel or whoever you hire, or even if it's just internally, you're going to have some recommendations. And those recommendations really should be followed because you have followed all these other steps leading up to your final conclusion.
So documenting your investigation, your final step in the process. Before you document anything in writing, the consideration is to also deliver a verbal presentation of the facts. You really have to, it's case by case scenarios based on specific facts and the circumstances, but you should have a discussion about, do we want to reduce all of this to writing? And there are reasons why you would want to reduce it all in writing, because you may need it later on and you want to have it documented. There are reasons why You may not want to have it fully documented. One of them being you may not, if it's there's no privilege, if privilege doesn't attach or there's a determination that the attorney-client privilege was waived, then that report, for better or worse, can be exhibit 1 in any plaintiff's allegations against the organization. So you really want to think carefully about whether or not you're going to do a verbal presentation or put it all in writing. Sometimes we do a mixed approach where we'll set forth the scope of the investigation in writing, we'll set forth the investigative process, we'll set forth some of the policies that we reviewed, and then we kind of leave a slide or a section that just says findings, right? And then that's verbally presented so that there's not a record of all the findings. And then the recommendations could be, depending on what they are, could be just a verbal report or it could be reduced to writing. So these are something that you should consider before reducing anything to writing. But if you do reduce it to writing, the report should always contain, again, the scope of the investigation, going back to your original investigation plan, right? You want to have your scope. You want to very carefully detail your investigative process. Who did you talk to? When did you talk to them? How many times did you talk to them? Were the interviews in person or were they remote? Who was at the interviews? Was counsel present or not, right? You want to keep a detailed log of that. You also want to talk about the evidence you reviewed, right? You want to say, I looked at all of these policies. I looked at these are the custodians that we reviewed, their emails, their text messages. You want to have the investigative process. The putting in the investigative process is so important because a reader, when they see all the work that you put in, they then are going to trust that you got to the right reasonable conclusion, right? If you just put in, here's my scope and here's my decision, our determination, the reader is left, well, how did you get there? Like, what did you do to get there? So laying out your investigative process is very important. You also want to put in a summary of your witness interviews. Again, you're going to have your own independent interview memos for each of the witnesses. So the report doesn't have to be a full memo of everything they said, but you want to do a nice succinct summary. You always want to include your credibility determinations, go back to those factors and say why you thought the witnesses were credible, because that's important in reaching a determination. And you want to include recommendations regarding any type of corrective measure.
So I think we're running close to the end of the hour. Let me just hit some very high notes on communications and protecting communications. This is really challenging, whether and how and to what extent you communicate about the investigation, about the determination. There's a lot of different stakeholders, internal, external, and sometimes your interests kind of point in different directions. And I want your thoughts on internal. My 2 cents is for internal communications about an investigation, less is more. If you think we fired Jerry for sexual harassment is the better of the 2 options on the slide, raise your hand. Good. We fired Jerry for sexual harassment is not only a potentially inflammatory legal conclusion, you don't have to get there in an investigation. You merely have to determine that Jerry violated your organization's code of ethics or code of conduct or some of the policies that we've talked about. And depending on the timing, if you go spreading that communication around before your organization has finalized a settlement and release of claims with the target of your investigation, guess what? You've just driven up the cost of settlement. If you spread that communication around post-settlement, then I think there's some risk that you may violate a non-disparagement clause or a non-disclosure provision. So less is more. I don't know if you have any war stories or thoughts.
No, I completely agree. Less is more. There's always going to be a few employees who feel that they have a right to know. So what happened, to Jerry? Why aren't you going to tell me? And just do the best you can and just say, sorry, it's not up for discussion. This is what happened, and say, and if you need to, then be assertive and say, this is confidential. You don't have the right to know anything. But people are going to talk. Jerry's going to call back or text back to some of their friends at the office and say that what happened. But just like you're reminding everybody all along the way when you're interviewing them, this is confidential. It's the same thing. It applies to the CEO, the COO, in-house counsel. Everybody needs to keep really the details of all this stuff confidential. I know you're going to talk about the press thing.
Yeah.
One point is, if it's the New York Times or the Wall Street Journal or the Washington Post, pick up the phone, okay? Get your communications director, or if it's you, pick up the phone. We had an issue where, I kid you not, Sputnik News called, when we were going through this big investigation, called and wanted to talk to one of our board members. And I had to admonish her very strongly, don't ever pick up the phone for Sputnik News. It's only 3 newspapers that we're going to be worried about here. Now, everything got out to everybody else, but I was kind of scratching my head that she was like, oh, so Sputnik News called, is it okay? I'm just like, what? So you want to be able to control the message, because it's going to get out, and it's going to get out fast. And if it's something that is high level, you're letting your CEO go or something, or you uncovered a major financial issue, you want to be way ahead of it.
I'll just say amen. Right. I mean, again, who are you dealing with, right? If you're dealing with an auditor or a regulator, you probably want to give the bare minimum information that you can to allow them to do their job. If you're dealing with the press, you might want to be more proactive so that you can control the narrative. Some organizations hire outside PR firms. Just consider that it's really hard to maintain privilege for communications between the organization and the PR firm. Basically, have to show that the PR firm is effectively an employee of your organization, or so necessary that you can't give legal advice without it. That's a pretty hard standard. One option is to have your outside counsel, if we're running the internal investigation, to hire the PR firm. I know that we're at 1:30. Just attorney-client privilege, really briefly, a communication between privileged persons made in confidence for the purpose of seeking or rendering legal advice. It's that last part. What is the primary purpose of the communication where this stuff gets hung up? Has anybody sent a business email and copied their outside lawyer and thought, I'm safe, this is privileged? It's not. Okay? If you are an in-house lawyer and you are acting in your capacity as a lawyer, the privilege likely attaches. If you're wearing your COO hat, it doesn't. And one cool thing about our job is that sometimes Doreen and I and George are tasked to serve you as lawyers, and sometimes we're your therapist, and sometimes we are giving you business advice. Slapping attorney-client privilege, doesn't protect that from disclosure. If you are looking in anticipation of litigation, attorney work product is broader than the attorney-client privilege. Sometimes it's easier to assert. The general rule is, that it protects communications to auditors, for example. There is one cautionary tale, and I think I'll end on this. This was a case out of the Eastern District of New York about 8 or 9 years ago. Cumulus. This was a case where the court compelled the organization to disclose communications between it and its outside lawyer, because the outside lawyer was not just giving pure legal advice, but it was giving instructions to the organization how to conduct the investigation. Here's a draft script to use with the complainant. I was telling Doreen earlier, this scares the bejesus out of me, because I do that all the time. And it's something that it's part of our job. We write draft talking points. We give a blend of legal and business advice to help get you through the investigation. It does not necessarily protect it against disclosure in litigation. So it's something to keep in mind. We're going a bit over, George. Should we wrap up?
Yeah. How much more?
It's like 2 hours.
I think the rest are just about privilege. So,
Okay.
there you go.
Good. All right. Well, not too far over. Really appreciate everyone's time and thanks. Join me in thanking Doreen, Eric, and Jesse. Great presentation. If you have any other questions, there's our contact information. Otherwise, have a great day.